54. The reason is this: my mother is unwell. Serial number 54. I informed Mr. Sundar. I'll do it.
It's 2014. Please wait. Let us see what will happen. Yeah,
Well,
Well, Ashok, serial number 55. Sin is not well. He is suffering from migraine.
Which is said no. 55.
55. Oh,
Yeah, for tomorrow.
Let
Serial number
51 mala. Friday I take notice.
let's
serial number
serial
14.
num-
Can't see you.
Number 14.
40.
14. It's for complaints.
Serial number?
14, 14.
well, serial number 41, my lords.
Yes.
Let's day after tomorrow, my lords.
Next week.
Or on Friday, my lords.
Next week.
Please, my lord. Date may be fixed, my lords.
Fourth.
Please,
Fourth.
please.
Fresh matters. Serial number 1. Shri D.R. Rajshekhar.
Yes.
It's not to be acquired. Measuring the 4 acres, 9 kunta. But we made a representation that in the portion of the land measuring 20 kunta, he has put up construction. Having dwelling.
What is the next area?
Annexed and when we made a representation, it has been excluded from acquisition. I made a representation that particular 15 kuntas may be demarcated. And no objection may be given for enjoying that property. From acquisition it has been given up. No award has been passed so far as this 15 kuntas is concerned.
Take out notice.
So I
Notice.
because they are attempting to under the.
No, I will dispose it of. I'll hear them and then pass an order.
Yes. Take us if it is
No,
possible.
no.
I-
Release on Friday. AJ to take notice for R1.
One.
Who appears for BDA?
Krishna is there.
Murugesh Vicharati to take notice.
Murugesh,
For respondents 2 to 5.
Murugesh Karatu.
Tell them Friday.
Yes. Murugesh Karatu.
Serial number 2. Shri Pawan Kumar Ji.
Appearing for the petitioners, my lord. This matter, my lord, land is being acquired. Their notification, preliminary notification is 18/4/2022, my lord. That is challenged. But this is, my lord, for the purposes of linking the peripheral ring road with a nice link road. The peripheral ring road, my lord, from the last 17 years, not 1 inch of road has been laid. Identical circumstances, my lord, where lands were sought to be acquired for the junction improvement and the toll plaza for the peripheral ring road was struck down by this honorable court. Division bench uphold it, my lord. Honorable Supreme Court also upheld that you finish the ring road. Then if you need more land, then you go ahead and acquire it. I'm, my lord, in the same kind of a
Where is the
situation.
notification?
Lord, notification is at page 42, my lord.
Integration of peripheral ring road.
Please, my lord. To link up the ring roads, my lord.
Notification is of the year 18/4/2022.
Il PRR, my lord, it's not seen the light of day for the last 17 years. My lands, my lord, are at page 48. And this is a layout, my lord. There are 36 petitioners who are the house plot owners, my lord.
Can there be a scheme by the BDA for the purpose of integration of 2 roads?
Because BDA is the answering authority, my lord.
No, but
I'll
you will have to
inquire it.
sanction the scheme, isn't it?
Yes, my lord, I'll inquire it.
My lord, may please see volume 4. The orders that were passed by this honorable court, my lord, when lands were sought to be acquired for the junction plaza. my lord.
Take out notice to them, I'll hear them and then consider your entry.
Please, my lord.
AGA to take notice for R1 and R2
R1 and R2.
next year. ಅವರೇ ಮಾಡ್ತಾರಂತ ನಾವು ಮಾಡ್ಬೇಕಂತ. B. Vachan to take notice for BDA. We list next we will wait.
My lord, a date may please be given, my lord. My lord, it may be clubbed along with writ petition 19043. It's a challenge to the same notification.
Right.
043.
Serial number 3, Muni Reddy M.
23 now.
Allotment of, cancellation of allotment of EWS site, my lord, on the ground that payment has not made. In fact, I have made the payment.
ಎಷ್ಟು ದಿನ delay ಇದೆ?
Due to COVID, I have not paid. And I immediately after reopening, I have paid, my lord. My lord, may kindly see,
You notice.
page 21, Annexure E, 14 September 2020, I have paid it.
Shri M. Munikrishnan to take notice in the next date of hearing. Interim order ಹೇಳಿದಾರಾ?
Please,
The respondents are directed not to allot site number B3 SA 246, measuring 20 feet into 30 feet.
Serial number 4, Suresh Babu.
An extent of 700 square feet lot is been utilized for the 100 feet peripheral, 100 feet road lot. Lots, now the BD has recommended to allot an alternative property lot, make sure you have to lot page 28.
Okay, to take notice for R1. Shri B.S. Sachin to take notice, respondents 2 and 3. We list next week on date.
4th. Serial number 5, D.K. Chandrasekhar.
Subjection.
Last 2 decades, the petitioners are fighting for their land. But annexure A is the order part. Even though there is a specific direction from the honorable court to hear us, to afford an opportunity, opportunity has not been given, violating the principles of natural justice.
What was the request before the for the government? Deletion. Deletion of land, sir. What was the request before the?
We have 5 detailed objections also. And the order is, the last order is at annexure C. Annexure C, violating this order, they have proceeded. Annexure C in the kind of page 76. And this honorable court has given the liberty of filing the fresh representation also. We have agreed. Opportunity ಕೊಡಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಹೊಡೆದೇ ಸಡನ್ ಆಗಿ after lapse of 3 to 4 years of this order.
Madam, take notice.
Issued orders passed.
After
Elaborate-
hearing the parties only, this order came to be passed, man. It is very clearly narrated in the operative portion of the order. at
He
page
says he has
57.
not been heard.
It is
Page
very
number?
clearly, page number 57, my lord, last para. The process of acquisition of the lands of the petitioner was completed before issuing final notification, after hearing the objections of the petitioners, on taking into consideration
No,
several.
that is the SLAO.
Yes.
What about this? Wasn't
they
the principal secretary required to hear?
And the earlier court directions also in this man.
Now, what was the order at page 73, na?
Page 73, this honorable court has gave direction to consider the representation, my lord, afresh. Accordingly, that their representation has been considered, my lord. At page 54, they have extracted the operative portion of the order. Okay.
You are not heard in the matter?
No, we have not heard in the document.
I'll get the instructions,
No, we have not
whether
heard
they
in
have
the-
considered the objections.
I'll have it day after tomorrow. If they're not been heard, re-hear them again, pass
Yes.
out.
So repetition will be held. in specific
Day after tomorrow.
28. Serial number 6, Shri Ramesh Chandra.
order. As per reviewed order.
ನಾಳಿದ್ದು. We list.
Sorry, I could not hear.
The initiation of acquisition proceedings. There is a dispute and a suit is pending.
In consider ಅಂತ.
Consider, yes.
Consider what? What is your prayer?
Now, my prayer is till the disposal, if the award is passed, should not be dispersed till the disposal of the suit. OS 80, 2009.
Take notice for KD.
for KDB.
ಇನ್ನು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರು ನಾವು ಹೇಳಿದಾಗ ಮುಟೇಶನ್ ಹಾಕ್ತಾರೆ.
CH to take notice for respond number 1. Ram Krishna to take notice for 2, 3, 4. Iವ್ರು R5, R6, R7.
ಅದ್ ಬೇಡ, ಅವ್ರು R5 ಬರ್ದಿದ್ದೀನಿ ಮಿಟೇಜ್ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ ಅವ್ರ ಹತ್ರನೇ ದಾವ ಹಾಕ್ಬೋದು.
R5 to 10 has sold the property to R11.
No, are they parties in the suit?
They are parties.
Take out notice on the council who appears for them in the suit. Petitioner is permitted to take out notice on the council who appears for respond number 5 to 12. Invoice number
5 to 11. 5 to 11 month.
86/2019. What about 12?
12 is the ಇವರು KDB ಅವ್ರನ್ನ ನೌಕರ ಅವ್ನು ನೀವ್ ಏನಾರ ಮಾಡಿ ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ, ಅದಕ್ಕೋಸ್ಕರ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ. ದಟ್ ಇಸ್ ದಿಸ್ KDB
ಹೇಳ್ತೀರಾ ನೋಟಿಸ್ ಹೇಳ್ತೀರಾ R12 ಗೆ?
ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ
ಅವ್ರ ಕೇಸ್ ವರ್ಕರ್ ಆಫ್ ದಿ KDB.
Means individual capacity they have made them.
ಇಂಡಿವಿಜುವಲ್ ಕೆಪಾಸಿಟಿ.
Individual.
ಏನ್ ಹೇಳಿದ್ರು ನಾನು ಹಿಂಗೆಲ್ಲ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Issue notice to
ಅವೆಲ್ಲ
R12. Council is directed to furnish a copy of the petition to the council appearing for KDB, who shall in turn ensure that copy is served on R12. Materialist on. ಅವ್ರಿಗೆ ಕೊಡಿ, ನೀವೇ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ನಿಮ್ ಕೇಸ್ ವರ್ಕರ್. 2 weeks ಬೇಡ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಡ್ತೀನಿ.
ಕೊಡ್ತೀನಿ.
Serial number 7, Shrikant NV.
For the petition. Next year, may not be. There are some office objections, my lord, I will come back today.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೀವು ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿಲ್ಲ.
I have paid it, there are some offices, I will comply it now.
300 ರೂಪಾಯಿ ಕಟ್ಟಬೇಕು ಅಂತ.
ಕಟ್ಟಿದೆ, ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕಟ್ಟಿದೆ.
ವೀಕ್ಸ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಬೆಳಿಗ್ಗೆ ಕಟ್ಟಿದೆ.
What is the next area?
Next year, the endorsement issued by the KDB, my lord. Page number 11. There is a suit is pending, my lord, in voice number 168 of 2020. Hence, my lord, the award amount has not been released in favor of the petitioner.
How can they release the amount if there is a suit?
But in the earlier order, my lord, the WP number 15771 of 2023, I have made the
Page?
special deal, my lord. There is a specific order by the honorable court, my lord, to release the amount. Annexure D, my lord, the operating portion, my lord, page number 32, my lord. 32, my lord, paragraph number 7. In the light of the thing, the general award of annexure D and D and so far as the petition are set aside. Respondent KDB is directed to consider the request of the petitioner for having the compensation by way of agreement under section 29 of the and pass necessary orders within a period of not later than 3 months.
What was the subject matter of this writ petition?
Plus the server number 91 bar 3, madam.
Now, what did you challenge there? You had challenged, you had sort of quashing of the general award.
General award. General award has been quashed, my lord, and
On what ground did you challenge the general award?
general award, my lord, since they are ready to pay the amount, my lord, under section 29.
Maybe you were ready to pay, get the consent award
Consent
only
award.
because of objections of the other side.
Please, my lord. And there is a suit, my lord, is pending before the trial court. In voice number.
I think they're justified. How can they pay the money to you?
Till the disposal of the suit, my lord, the amount has to be kept in the civil court, my lord, sir.
Who appears for KDB?
I will take notice, my lord.
Till the amount, till the dispute is settled, keep the money in fixed deposit.
Yes.
But now that the general award is quashed, on what basis will they deposit? What is the amount that they'll deposit? You got the general award quashed.
Yes, my lord.
They can't give a consent award because there are rival claimants.
Yes, my lord.
Then which is
On
the
on
amount?
that ground, my lord, the endorsement has been issued by the KDB, my lord, the compensation amount has not been released.
ನೀವೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ ಇವಾಗ.
However, since there are many parties in the suit, my lord, sir, there is a partition suit, my lord, going on between the parties before the trial court.
Is the KDB a party in the trial court?
Yes, ma'am. Our party.
Why don't you make an application there asking them to deposit the amount into court there? What was the general award amount?
More than crore, my lord.
No, per acre ಎಷ್ಟು?
Sir, insta, because the instructions, you know, I will have to go through.
There is a award, my lord, 100%. We are
No, but
deposit the amount to the city.
There was an award, but because of their instance, the award is quashed.
Award question.
Award partially, connection DL, that is their order.
Kindly pass on, man. My submission. Kindly pass on, man.
I think you are responsible for this.
Yes, sir.
Serial number 8, Shri Muralidhar SR.
I am for the petitioner, my lord. I am for the petitioner. My lord,
One minute.
I am for the petitioners and it is with regard to the registration of Kata. The
Take out notice. Here. Shri G. Lakshmi Rao to take notice for respondents. Relist.
Seal number 9, Shri Vasant Kumar HD.
Well, the when Balakhamma was the owner of the property bearing survey number 35 and 36, supporting Nazari 5 acres 9 guntas situated at Mangal in the Eastern Province. She acquired the said land through court auction sale on 29/11/1996.
What is annexed M?
The annexed, you know, the
What representation?
representation given to the respondent to issue the no objection certificate to my property because the land has been converted by the original owner. She has sold the property 2,550 square feet in for a sufficient Jagidar. They have turned to sell the property in favor of me.
Gautam Dev C. Ullal.
Now,
Take
my lord,
notice.
even without considering my representative, they are trying to demolish my existing structure. And I put the photographs.
Who's trying to demolish?
The BDA responding.
I'll have it after tomorrow, get them.
And in the meanwhile, my lord, the not to demolish or not to dispose it from the.
The prayer is to consider.
No, because now they are all of a sudden even without issuing the.
Where is your representation? Where is your representation?
Another H must be the requirement for having received my representation. NOC need a bucket. Even after, even without consent, this representation, they are trying to demolish my existing structure.
Where is your representation next year?
Not I have given them the requirement for having received my representation.
Where is your representation?
I have given the submitted to the BDM loan.
Don't you think you should give a copy of that here?
No, because he has only received the copy. Here they are written that NOC need a bucket. They are.
Why can't you give me a copy of the representative you submitted? I can't issue a direction to them to consider the acknowledgement.
I will, next date I will produce it. In the meanwhile, my lord, the.
No, I'll have it day after tomorrow or tomorrow, get that representative first. Let me see what you're seeking for.
Not to demolish or not to existing structure.
ನಾನು ನೋಡ್ಬೇಕು ತಾನೆ representation.
Yes, yes, sir.
ನಾಳೆ ಹಾಕೊಳ್ತೀನಿ, ನಾಳೆ ಕೊಡಿ ಅದು
ಆಯ್ತು, ನಾಳೆ.
representation tomorrow. And get Gautam Dev C. Gullal. Shri Gautam Dev C. Gullal to take notice for BDA. Release to me.
Seal number 10, Shri RJ Hegde.
Vote fee ಕೊಟ್ಟಿಲ್ಲ. 300 ರೂಪಾಯಿ ಬಾಕಿ ಇದೆ ಅಂತ ಹಾಕಿ. ಕೋರ್ಟ್ ಫೀ ಕಟ್ಬಿಡಿ. ಕೋರ್ಟ್ ಫೀ ಕೊಡೋದು ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ತಗೊಳ್ಳೋದು ಮಿಕ್ಕಿದೆಲ್ಲ. No, but until the court fee is paid, I don't think I should issue notice. ಒಂದು ವಾರ ಕೊಡ್ತೀನಿ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. Weeks time.
Seal number 11, Shri Karnataka.
For the petitioner.
ಹೇಳ್ತೀರಿ ಮೇಡಮ್?
Well, they have not given any representation at all, my lord.
Verify whether compensation is paid or not.
This
Easy to take notice.
petition also, they have not marked any annexures regarding representation.
Item number 238.
This was notified, huh?
This is-
Check ಮಾಡಿಸ್ತಾರೆ ಮೇಡಮ್?
I will verify, my lord.
AJ to take notice
For
first.
that, they had to give representation without which
Release.
SMS cannot be issued.
And acquired by compensation to the representation.
I will inquire.
Next week. Fourth.
Seal number 12, Shri Omkaresha.
ಅದ್ರಲ್ಲಿ ಹೇಳಿ ನಾನು ಡೇಟ್ ಕೊಡ್ಲಿ.
Fourth.
Weeks time is granted to me. Well,
Seal number 13, Shri Shantappa.
From the petitioner. Dispensation I have objection.
ಇನ್ನು 5 ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ಮಾಡ್ಬಿಟ್ಟು ನೀವಿದ್ದೀರಾ?
The soda copies. The two matters, 13 and 15. 15, they made a local municipality because their allegation against the municipality that they are a total corruption. First case, whether they are not made, first case, they are not made any fault with the municipality.
ನಿಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಕೇಸಲ್ಲಿ ಮಾಡಿದಾರೆ, 15 ಅಲ್ಲಿ ಮಾಡಿದಾರೆ. ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಇಲ್ಲ ಕಾಣ್ತಾ ಇಲ್ಲ.
13 ಅಲ್ಲಿ SLAO KDB ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Respondent number 3. Case is that these lands are handed over to the local municipality, this jurisdiction they were. They made a part in other case, but I think they are necessary parties for this case also.
What is the prayer here?
Prior the seeking washing of the acquisition notification. But it appears in the subsequent version 21 in purchase.
91, madam.
91.
I'm the absolute one, 91 purchase.
Notification is of 2006.
Notification for what?
2006. Next side, email.
For what purpose was this acquired?
Industrial,
ಏನಕ್ಕೆ? Any specific industry or
Central trust.
general.
ಎಷ್ಟು ಅಕ್ವೈರ್ ಮಾಡಿದಿರಾ? ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್?
ನಮ್ದು 2 ಎಕರೆ ಇದೆ.
ಅಲ್ಲ, ಇವ್ರು
ನಮ್ಗೆಲ್ಲ
ಒಂದು
ಒಂದೊಂದು ಕುಂಟೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ
544 acres.
And description of the respondent was not properly described.
ನನ್ನ ಖಾತಾ ಕೂಡ ಆಗಿದೆ. ನಾನು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ನೆಕ್ಸ್ಟ್ ಎಫ್ ಮೇಲೆ.
When did you purchase?
91 ನಾನು ಪರ್ಚೇಸ್. ಪರ್ಚೇಸಿಂಗ್ ಫ್ರಮ್ ಗೋರೇಗೌಡ ಬಿನ್ ಜೋಗಿಗೌಡ ಎಂಬುವರಿಂದ ಸರ್ವೆ ನಂಬರ್ 96ರಲ್ಲಿ 1 ಕುಂಟೆ 1 ಎಕರೆ 20 ಕುಂಟೆ.
You are saying that this land was handed over to the municipality.
ಇವ್ರು ಏಕಾಏಕಿ without my notice.
Old Kurgali, old industrial area. So 2006.
Why was it handed over to the municipality?
Now yes, sir, and what they say, well, actually notification is what they produce is upgradation of local panchayat.
ಅಲ್ಲ ಅದ್ ನೋಡಿದೆ, ಬಟ್ ನಿಮ್ದು ಡಿಕ್ಲರೇಷನ್ ವಾಸ್ ಫಾರ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ.
Yes.
What did you do? Did you form an industrial area or?
Because they served a copy.
ಮುನ್ಸಿಪಾಲಿಟಿ ಗಾರ್ಬೇಜ್ ತಿಂಬದಕ್ಕೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ
ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದ್ರ ನೀವು?
ಕೆಲಸ ಹಾಕೊಂಡಿದ್ದಾರೆ, ನಮ್ಮನ್ನ ಅಲ್ಲಿ ಹೋಗಿದ್ದಕ್ಕೆ ನಮ್ಮನ್ನ ತೆರವುಗೊಳಿಸಿದ್ದಾರೆ.
ಇಲ್ಲ, ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತೀರಾ ಮುನ್ಸಿಪಾಲಿಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ?
ಅಲ್ಲ, ಅವ್ರು ಕೇಳಿದ್ದಕ್ಕೆ ನಾವು ನಗರಸಭೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ.
Take instructions. ಇದು serial 13 and 15. Who appears for the municipality there?
Which municipality?
Is there any standing council for municipality?
ಯಾವ municipality?
Party ಮಾಡಿದ್ರಾ? Party ಮಾಡಿ.
Num 13 and AJ to take notice.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4
and R2.
First case ಅಲ್ಲಿ ಮಾಡಿದ್ರಾ?
Take notice for R2. ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಸೇಮ್. ಮೈಸೂರು ಕಾರ್ಪೊರೇಷನ್ ಇದು?
ಅಲ್ಲ, ಮೈಸೂರು ಕಾರ್ಪೊರೇಷನ್ ಅಲ್ಲ. ಮೈಸೂರಲ್ಲಿ
ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಉಟ್ಕೊಳ್ಳಿ ಅಂತ. Then you should say Mysore City Corporation by and.
ಮೈಸೂರು.
annexure
Corporation Geeta Pappanna will appear.
Next year?
Page numbers ಹಾಕಿಲ್ಲ, that is our difficulty and there are a lot of operations. ಊಟಗಳಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಂತ ನೆಕ್ಸ್ಟ್ ಗೆ 15 ತಗೊಳ್ಳಿದ್ರು ದಯವಿಟ್ಟು 15ರಲ್ಲಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಮಾಡಿ.
City Municipal Council area ಉಟ್ಕೊಳ್ಳಿ.
ಮುನ್ಸಿಪಲ್ ಅಪ್ಗ್ರೇಡ್ ಮಾಡಿದಾರೆ, ಅದನ್ನ ಅವ್ರ ನೋಟಿಫಿಕೇಶನ್ ಆಗ್ತಾರೆ.
For city municipal council, Kurgali.
ನೀವು ತೊಗೊಳ್ತೀರಾ? ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. ಸೀಲ್ ನಂಬರ್ 13.
ಕೇಸ್ ಅಲ್ಲಿ ಮಾಡ್ದಾಗಿಲ್ಲ, ಸೆಕೆಂಡ್ ಕೇಸ್ ಅಲ್ಲಿ
Since 13, since it is contended that the lands with the subject of the street petition are handed over to the city municipal council area of Utgalli. The respondent petition is directed to complete city municipal council Utgalli as respond number 4. She is also to take notice for our council. ನಿಮಗೆ ಹೆಂಗ್ ಕೊಟ್ರು ಅವರು? ನಿಮ್ ಜಮೀನ್ ಹೆಂಗ್ ಕೊಟ್ರು?
I will go through the papers now.
List. Okay. Next week ಹಾಕೊಳ್ಳ?
First street petition also they should make the corporation as a party.
ಮಾಡಿದ್ದಾರೆ.
I agreed.
ಕಾಪೀಸ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಯಾವಾಗ ಹಾಕೊಳ್ಳಿ?
10 days ಅಥವಾ 15 days ಅಥವಾ
List.
11th.
ಫಸ್ಟ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ತಪ್ಪು ಮಾಡಿ.
Seal number city municipal council.
ರಾಜೇಶ್ ಅಯ್ಯ.
Now you have to pay the court fee. Court fee is not paid.
Waiting for 2 weeks now.
Issue notice, Srinivas Bhatt is directed to take notice for the respondents. Relist 10 days. and 10.
11th. Seal number 16, Shrikant NV. Here for the petition.
Maintain office objects to contain. The office objection will maintain.
Actually, the representation will not serve. If the petition to the second and third respondent. For release of the compensation. These are already. Acquired.
OPS for KRDCL.
Vijay Kumar Mala. Vijay Kumar.
AJ to take notice for R1, Vijay Kumar to take notice for R2 and R3. Really stuck. 10 days.
11th. Seal number 17, Shri Janandeya VS.
For petition in this case.
Bit of mandamus. Even representation to the respondent.
Who are the respondents?
Not considered.
AGA to take notice for respondents. Realist.
Fourth. Seal number 18, Shri Mukanappa SB. SB Mukanappa.
NHA 11 पर Shilpa S. Shah to take notice for R1. Issue notice to R2. Petitions Council is also permitted to take out notice on R2 personally.
Seal number 19, Shri Varadaraj Avaldar.
The petitions. Petitioners are 48 petitions are there. They want different sites, 725/1 of Kamagata village. This KDB sought to acquire these properties by a notification 1998. Thereafter, it has not been implemented at all. And it was sought to be acquired for formation of a nice road in this thing. It has not taken place. And in fact, KDB has given an endorsement on 25/11/2020 saying that there is no award, the property has not been taken into possession, all these things. So
Where is that endorsement?
next year, we may not.
Next year?
This is the copy of the notification, my lord, kindly.
No, you said that they issued an endorsement saying that the
Yes,
award is not passed.
yes, it is there.
You have not produced it here?
It is there, my lord. There is some difficulty in the pages that I didn't identify. Kindly, kindly.
What is the annexure?
Annexure B.
P. Chandrasekhar to take notice for respond number 2 and 3. AJ to take notice for R1 and R4. Why have you made the BBMP a party?
They are not making Khata in the next of this particular.
BBMP here. Power command to take notice for R5 and R6. Relist on 10 days.
11th. Seal number 20, Shri Dayananda KG.
Petition filed seeking land of signature to BDM to execute absolute sale deed.
Shri Ajay Kumar M to take notice for respond. Relist next week on date.
4th. For orders. Seal number 21.
My lords, appearing on behalf of the petitioner, my lords.
Who's R2 and R3?
My lords, R2 and R3 are the children, my lords, of R1, my lords.
Since R2 and R3 are the children of the deceased R1, the memo filed to treat them as the elders of R1 is accepted. What is this IA 1/22?
My lords, that was to bring the LRs on record.
No, If the memo is filed saying that they're already recorded, where is the question of abatement?
My lords, I had filed the memo later on subsequently, my lords, after the death was reported.
The LRs of R1 were already on record. And orders passed on the memo stating that they should be treated as the LRs of R1 and R2. IA1 and IA2 of 22 would be unnecessary. They are accordingly disposed of.
Highly obliged, my lord.
Abatement ಆಗಲ್ಲ. Accordingly, abate ಆಗಲ್ಲ.
Seal number 22, Shri Ajesh Kumar.
Who's R1?
Appear on behalf of the
I'll
respondent.
say it is abated.
My lords, I'll file the necessary applications, my lord, we're not able to.
When you
accept-
make the application, it come up. When did he die?
Old matters. My lords, I got to know when the postal shara showcased that he was dead. I'll just ascertain the details and file.
No,
necessary-
according to the post sheriff, when did he die?
They made 23, my lord. Sir, last date of hearing itself is 23.
10th of January, na?
Steps ಅಂತ available.
Steps have not been taken in respect of the deceased R1 within the prescribed time, comma. The petition as against R1
My lords, I'll file
stand
necessary application. my lord.
abated.
Yeah.
As in when you file an application, I'll allow it.
Seal number 23, Shri Arun BM.
In office objection, or
ಎಂದು ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ earlier KVH ಗೆ served you are served earlier. And then petition copy, a plain copy, that's also we had filed along with the petition itself.
acknowledgement file, give it ಹಾಕಿದ್ರಾ?
You taken served on that day.
Received the copy.
Yes. Yeah, it is there for judgment before the trial court. I had moved it in emergency on Friday.
What is the matter about?
Original suit. Your achievement, can you see the cost item for a moment, like page 6 of the CRP? The fourth defendant is in revision before this report, Karnataka Central Diocese. It's a church under the Church of South India. Church of South India is for 4 southern states along with Jaffna in Sri Lanka. The fourth respondent hearing is a local church, St. John's Church anta. Adralli elections, fast-track committee. Respondents 1 and 2 hearing were the plaintiffs. They were removed as secretary and treasurer, and also from a membership of the church suspended, and inquiry was constituted. Now they are challenged the proceedings. They are challenged on the ground that the executive committee decision is wrong anta challenge ಮಾಡಿದ್ರು. That trial court granted injunction against me, telling that bishop is the authority under clause 26. But the executive committee has taken a decision. Therefore, bishop should have taken the action until they said, the trial court said. Then bishop took independent action based on the trial court's interim this one. That was challenged in injunction application, saying that original injunction itto bishop should have sought permission of the trial court before taking an action anta. We put forth the contention, if the superintending engineer had taken an action, if the honorable court says chief engineer has to take action, he will take independent action. The trial court was the view that they should have taken permission of the trial court before taking action. It injuncted us again. That was challenged by us in MFA. This court observations were made, but in the end, this court set aside the trial court's order and dismissed the IAS. That was taken up by them in the Supreme Court. Supreme Court dismissed the petition filed by them. There afterwards, I filed an application that they had challenged the original order of the executive committee. They had not challenged the subsequent order of the bishop. IL challenge ಮಾಡಿದ್ರು suital ಮಾಡಿರ್ಲಿಲ್ಲ. We took up it, IA-10 was filed, the truth prayers have become infructuous and based on Supreme Court judgment that subsequent decision of the bishop on 17/6/2022 is not under challenge. Trial court reject, kindly see the list of dates for a moment.
They have not filed a separate suit challenging the subsequent decision.
Illa.
You not challenge the decision of the bishop?
There is no decision of the bishop. There is no decision.
That was challenged in IA by them.
There is no decision, and this court held that the bishop could not have passed a second order, and contempt proceeding should be initiated against the bishop for having passed a second
Where
order.
is your plaint? Where is your plaint?
Page 1, my lord, in the compilation of.
My lord will see, I will point out the plaint. The second order of the bishop was held by this court to be in contempt of the earlier order of the trial court, and
No,
this court,
The application that has been filed, IA number 10,
yes.
was to dismiss the suit as the
Yes.
players have become infructuous.
You know, it was filed in 2023 when the matter was finally being heard. and he relies upon a November 22 order of the High Court and insisted upon the court to consider his 151 application, even though the matter was being finally heard. We took the contention since the matter is being finally heard, and his contention is on maintainability because we didn't challenge it separately. It could have been well raised in his final argument. But he insisted upon the honorable court to consider his IA first, even though we were at the stage of final hearing in 2023 November after a year. And the court, in its own wisdom, conceded and accepted his request and then passed the order on IA number 10. It held that once an order is passed and it has become final, and the bishop was restrained by an order of the court from proceeding against these respondents, he had no right to proceed against these respondents. That order is null and void. In the MFA, which was filed by them,
The trial is over.
trial is over, reserved for judgment.
My lord, sir, Honorable Supreme Court.
No, I mean, my lord, may I finish? Or let him finish and then I'll respond. I mean, let's, I mean, I don't know. Since the court, no, I'm not, of course, yes, court will permit you.
Abruptly trial court.
No, may I make this submission? My lord, this is a,
What is the prayer in the plaint? Come to page 48.
where's the plaint?
Declare that the plaintiffs are duly elected members of the Passport Committee and elected to the post of Supreme Treasurer, respectively of the Passport Committee for triennium 2024. That the prayer.
How will this become infructuous?
Sorry, please. Subsequently, Bishop has taken an independent decision, my lord. Your lordship may.
No, that is another thing. They are saying for the year 2021-2024, declare that they were duly elected. That prayer, how will it?
Duly elected, I know this one.
Then how can the suit become
But
infructuous?
subsequently, they were removed from the post. That was.
That's a separate cause of action. How will this prayer in the suit become infructuous?
See, this is become infructuous. Kindly see the cause of action on page 47.
Prayer will it become infructuous?
Cause of action based on that cause of action prayer.
Maybe so, but the prayer will not become infructuous.
Prayer, please, an opportunity could be clear.
See, suppose a declaration is given to them that they were validly elected. Whether they have been removed subsequently or not is of no consequence. The court may take the view that I may not go into this question because of the subsequent.
Orderly. Contrary views taken by the court saying that they can file amendment to bring that prayer and orderly.
It's an unnecessary advice given to them. As far as I thought, it's only a declaration they're seeking. If they're entitled, they'll get it, or else they will not get it. Why do you say it's becoming?
Written statement, application is kindly otherwise, if there is a fault on my part, I beg this.
No, I'm not trying to say, I'm not saying it's your fault. I'm only saying that the suit will not become infructuous.
Contest opportunity could be called to. Kindly see the list of dates for a moment, my lords. I understood your lordship this one.
IA number 10 is only to dismiss.
Infractions.
Why do you want to press that IA?
Let them give an opportunity for me in that trial.
Make an application. You'll have to make an application there. I can't.
The trial court is very harsh on me, telling that I have committed contempt. This application is not maintainable. I should be hauled up. Kindly see the list of dates for a moment, my lord.
Arun, without you making an application saying that you have not been given an opportunity, how can I pass an order preemptively saying that you?
The application pending it too. Kindly see the list of dates for a moment, my lord. Kindly see page 2 of the list of dates. 2 minutes, my lord, not in other matters. This matter and request, Martin. Your lordship may kindly see at page 2 of the list of dates. Only few dates I will mention and leave it to the honorable court. Page 2. 14/11/2022, MFA was dismissed by this court. Supreme Court dismissed the special leave on 14/12/2022. My lord, may kindly see the next date, 10/7/2023. Earliest point of time, I filed this IA for.
If you were to make an application, I'll ask the trial court to consider the application within a week.
Well, that is a matter which is, I mean, he did not take an order from the court. It's his liberty to do that. It will prejudice the mind of the court. And effectively, my lord, can I, please?
You have to address me. So stop addressing me.
My lord may kindly restrain it.
Passing an order, right?
I'm sorry. My lord, that would not, I mean, my lord, this is a civil revision petition. In case he makes an application, he need not seek the permission of the court. It sort of muddies the matter. If he has a right in law, he can make an application. There is no, may I make the submission, my lord? If my lord permits it, and effectively my lord is putting a hurdle in the way of the judgment process, which I have serious objections to. Therefore, my lord, if he files an application, it's up to him how the court considers. If the court considers one way or the other, his remedy lies in a writ petition if it goes against him. We will handle it there. But for a civil revision petition where he is challenged an order on IA number 10, for the court to leave IA number 10 and to proceed to pass an order, it's not a writ jurisdiction. My lord is only considering the order on IA number 10. And the IA number 10 was for dismissal of the suit at a time when the matter was being finally heard.
Again, an abuse of the process of the court. May I ask this question? My lord will consider it. Why would a party at the stage of final hearing, when he could have well raised the argument of the suit having become unfructuous in final hearing, move an application under 151? My lord, may I straight away ask that question? Only to derail and protract the proceeding. My term comes to an end in June 2024. By this process of now filing an IA and again seeking permission, you are basically rendering my suit infructuous. I have serious objection to this. By dilly-dally and lost delays, my right to a decree of the court is being denied. Now, my lord, whether the decree comes in my favor or his favor, it is only for the court to decide. I'm not for a moment now trying to, neither can my friend say that the judgment will go his favor or my favor. It is reserved for judgment. Let that process not be set at naught. And my lord, once the matter is posted for judgment, my lord is well aware that no interim application can be entertained. And if my lord is passing an order, it will be contrary to law. And it's IA number 10 is what my lord is considering. And if my friend wants to argue on IA number 10, we will argue, and my lord will consider IA number 10 appropriately. But to pass an order beyond IA number 10, as though my lord, with due respect, my lord may not take me amiss. I hope I'm respectful to the court. I only would say that it would interfere with the adjudicatory process of the trial court, and for which there is a bar by the Supreme Court that once the matter is posted for judgment, that stage should not be retracted back. Now, it's not as though he is remediless. He has come by way of a CRP before this court on IA number 10. In case, I don't know how we can predicate that the order will go against him. In case the judgment comes against him, he obviously has the RFA and he can get a stay of the judgment. So it's not remediless for the court to interfere in a revision principle.
What do you mean by saying?
And may I make the submission? Kindly see the order sheet on the last hearing date. Kindly see the conduct.
Your lordship may kindly see the list of dates for a moment. Trial court is very.
One minute, I'll just finish this.
Its order, clear order.
Learned counsel for the defendant, this is my learned friend who appears, praised time to submit arguments. So it's not as though he wanted time to file an application. Yeah.
And the trial court, it is there in this list of dates. Two days time is given after their arguments, only 2 days time. And then when the order is not released by the trial court.
When was the defendant's evidence taken as nil?
My lords, may kindly see this list of dates for a moment. The 10/7/2023, my lords. Two list of dates, I think I can leave it.
Here the judge has said.
Sorry, I mentioned to the court.
No, if he is aggrieved by this order, he has to file a writ petition, not this court.
Kindly see.
When was the defendant's evidence taken as nil?
Subsequently, my lords.
Then give me the date, just the date.
That was on 27/6/2023. 27th, your lordship will get it at page 232. 27/6/2023.
So you have not filed your written statement, you cross-examined.
Because question of lie.
Chosen to lead the evidence.
My lords, 27/6 defendant evidence was not taken as nil. Kindly see page 2 of the list of dates for me. Two dates.
I am not actually, he's right in that sense. I am not sitting in judgment over the orders that have been passed. I'm only on IA number 10. I thought if you have cross-examined the witnesses, you have not heard in the matter. I thought I'll give you an adjournment. I'll give you.
I address the court. Kindly see page 2, my lords. 10/7/2020, 27/6 court said defendant evidence taken as nil. 10/7/2023, we filed an IA. IA 10 filed by the petitioner to dismiss the suit as threats have become infectious. In view of the subsequent event and suit is not maintainable. Counsel for respondent MK argues on that. Then on 17/7/2023, the petitioner was heard on IA number 10 and the matter was posted for orders on 31/7/2023. Then orders were not passed for 7 months. Orders were passed only on 18/1/2024. Then I applied for certified copy on 21/2024. Trial court, the matter on 13/2/2024, certified copy is not given to me. They argue on 13/2/2024. 15th, it was listed for my argument, 2 days thereafterwards. On 15th, I request the court, certified copy kottilla, yen bardidira anta, to take steps in the matter or argue on the main. Kindly grant me 2 days time till the certified copy is
When was the order passed? Defendant's evidence, not, no.
27/6/2023. 27/6/2023.
and that order has not been challenged.
No, that I find.
No application is filed for recalling that order.
It was filed, imposed cost of 25,000, which is not paid. It was allowed on cost.
Here you're screaming, I mean, I think we can, this audio is also.
No, because he's misleading the court. An IA was filed.
Just asking him, I don't know.
He's not saying the truth. IA was filed for recall.
One of you decide, who will argue, so then.
No,
it's
since
easier.
my lord posed a query and
No, I posed a query to him.
he's not saying the right answer.
You get a chance right
All right.
afterwards.
Sorry, man.
On 27/6/23, according to you, defendant's evidence was taken as nil.
Please, madam.
You made an application for recalling the order and for.
No, I filed an application, suit rates have become infractions.
So until you make an application for recalling and setting reopening,
That the court did not give opportunity because 18th, the order was passed.
27/6/23, the order was passed. After 27/6/2023, you have not made an application.
No, ma'am.
So until you make an application, no question of giving an opportunity.
No, dependent evidence, at least, this order.
At that stage, whatever happens from there, it will continue.
Please.
If you made an application, the court will consider, but I can't consider. I
ನಾವು ತಾವು ಮಾಡ್ಬೇಡಿ ದಯವಿಟ್ಟು ಅವಕಾಶ ಕೊಡಕ್ಕೆ ಹೇಳಿ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕು ಅಲ್ಲಿ ಇವಾಗ
ಹಾಕ್ಸ್ತೀನಿ. I file a-
ನೀವು ಹಾಕೊಳ್ಳಿದ್ದೇನು they will do whatever is required in law. If the law permits them to reopen, they'll reopen.
ಅಲ್ಲ ಇವತ್ತು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಮಾಡಿ.
I can't stay the judgment. How can I stay the judgment?
Judgment ಅಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡದೆ you can't post it for judgment. I am only a natural justice. Kindly see, my lord, certified copy was granted on 22/2000.
Arun, the best thing is I simply adjourn this by 1 week, so the problem will be solved, one way or the other.
Some intervention, 227 and.
No, for the past 1 year, if you have not made an application for recalling.
2022 matter. 2022 matter. I diligently prosecuted the matter.
You don't file your written statement. You don't cross-examine PW1.
No, because.
You don't adduce evidence. After that stage, you make an application to treat the suit as infructuous. Nothing prevented from making an application at that point of time, saying that my application, and he says one application is filed and the cost of 25,000 was imposed for reopening the case.
I have 10 dismissal mele, 25, not that.
No, again misleading.
10 dismissal mele, 25,000.
Where is the order passed on the application for reopening?
No, IA 10. IA 10.
25,000 ಇಲ್ಲ. I have 10 mele.
Order, even that order is there. My lord will punish.
You said an application for reopening.
Yeah, it is there.
That was dismissed.
Yes.
Trial courts, my lords, at least on 5 days.
Your approach is also not very noteworthy.
ಈ ಆರ್ಡರ್ ಯಾಕೆ ಮಾಡಿದ್ರು ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಆರ್ಗ್ಯೂ
ಏನು ಆರ್ಡರ್ ಮಾಡ್ರಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ತಾನೆ.
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್
ನಂಗೆ ಡಿಫೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಮಾಡಿದ್ರೆ ದಯವಿಟ್ಟು ರಿಓಪನ್ ಮಾಡಿದ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿರಾನೆ. You went on arguing another application.
7 months.
You are blaming the court for
No, I'm not blaming. 7 months court takes to pass orders, then 2 months to
You have
grant
taken
copies.
1 year, you have not even made an application. Look at your conduct.
An application was
You-
pending for infractions anta.
Without you filing a written statement, what is the cross-examination that you will do? You have not even filed a written statement.
ಅಲ್ಲ that's.
So he is right in a sense. Now if I
ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಟೈಮ್ ಕೊಡಿ ಅಂತ
Why?
ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಕೋರ್ಟ್ಗೆ. ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಕೊಡ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಬೇಡ, ಕ್ವಶನ್ ಆಫ್ ಲಾ. I have permitted to argue the matter.
file your written arguments, they'll consider it. ಅಲ್ಲ ನೀವು ಬುದ್ಧಿವಂತರ ಅವರು ಬುದ್ಧಿವಂತರ ಆಗ್ತಾರೆ. ನೀವು ಸ್ವಲ್ಪ WS ಹಾಕಲ್ಲ.
ಅವಕಾಶ ಕೊಡಿ ಸರ್.
ಅಲ್ಲ WS ಹಾಕಲ್ಲ ನೀವು. ಪ್ಲಾಂಟಿವ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಮಾಡಲ್ಲ. ನೀವು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. ಏನ್ ನಿಮ್ಗೆ ಅವಕಾಶ ಕೊಡ್ಬೇಕು?
ಅಲ್ಲ it is question of law. Subsequent prayer is not sought. I can argue on question of law. ಅದಕ್ಕೊಂದು ಅವಕಾಶ ಕೊಡಿ. 13th ಈ
File your written arguments, the trial court will consider.
ಪರ್ಮಿಷನ್ ತಾವು ಮಾಡ್ಲೇಬೇಕು. Otherwise I'll file return arguments.
ನಾನೇನು ಪರ್ಮಿಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ನನ್ ಮುಂದೆ ಇರೋದು ಬರೀ I-10 ಮೇಲೆ ಮಾತ್ರ.
3 o'clock judgment ಗಿದೆ. He will not allow.
ಮತ್ತೆ ಆಗೋಗಿರುತ್ತಲ್ಲ ನೀವು written ಕೊಟ್ರೆ.
No, my friend has the right of appeal and stay.
Why are you interfering when he's arguing?
Okay, fine.
What will you gain?
Nothing.
At least to return arguments of the permission, but it's an institution. My lords may kindly see, 31/7 it was posted for orders. ಅಲ್ಲ ಆರ್ಡರ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ how can I file an application to recall? Your lordship may kindly take that into consideration.
Immediately after the order was passed on 10/7/2023, nothing prevented you from making an
ಆರ್ಡರ್
application.
ಮಾಡಲಿಲ್ಲ. ಆರ್ಡರ್ ಮಾಡಿದ್ದು 18/1/2024.
18/1/24 ಆಗಿದ ತಕ್ಷಣ ಅಪ್ಲಿಕೇಶನ್
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ was not given.
ಚಾಲನೆ ಮಾಡೋದು ಒಂದು. ಅವತ್ತೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಿತ್ತ ನಂಗೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿರಿ WS ಹಾಕಕ್ಕೆ ಅಂತ. ನೀವೇನು ಮಾಡಲ್ಲ ನೀವು.
I have got a right under CRP. That order I can challenge in this court.
Who's preventing you? You also have an obligation to make an application for filing a written statement. If you don't file, it means you've done.
I see the certified copy and argue the matter. That was not given. Kindly permit me to argue the matter.
I'll confine my order only to the validity of IA number 10.
ಅಲ್ಲ that IA number 10 I have to argue.
ಮಾಡಿ.
That IA number. Kindly see. Your lordship may kindly see the plain. I'm sorry, madam. Clause of at page 47. Only 2 sentences I'll read.
Yes.
The cause of action to file the suit arose on 28/7/2021, when in the morning service defendant announced the suspension of the plaintiff. So my lord may kindly note the word suspension. That suspension was pursuant to this. The lordship may kindly turn to page 83. They did not challenge that order. Page 83 is the order of suspension. Your lordship may kindly see the executive committee decision. Page 83. I will not take much time. I will just read one sentence. It was reiterated that an inquiry committee will be formed. I'm sorry.
Page 83.
25th November 2021. This was not challenged by them, but they said suspension they are challenging. It was reiterated that an inquiry committee will be formed to investigate into allegations leveled against so and so. The secretary and treasurer of the purchase respectively to the presbyter in charge so and so, the letter stated so and so. As these allegations, this abuse of power, willful obstruction of the church restoration project, misuse of church communication platforms, and disregard for the presbyter in charge, manifested in terms of directly humiliating him, instigating physical violence against him, etc. It was decided to affirm and the earlier resolution of the executive committee to suspend the membership of so and so in the trial committee for a trial. However, it was decided that if so and so tender an apology, they will be reinstated in the committee. This was challenged subsequently. This was challenged. Kindly see the order that at the initial stage at page 86. Only one sentence I'll read. Page 86. Order dated 21st April 2022. Kindly see the order. Your lordship may kindly turn to directly. I will not read the entire thing. Only one sentence of the order at page 154. 154. After considering all that, this is the order of the court, page 154, para 78. Only one para I will read. Apart from this, again on 8th November 2021, defendant number 2 wrote letter to the defendant number seeking the action and submitting. It also appears in the record that the meanwhile they constituted a peace committee, which there was no fruitful result of the peace committee meeting. It appears that on 26/11/2020, defendant number 2 convened a meeting on the raising for the purpose of electing the new secretary and treasurer for the remaining period of the trial and so and so to the said emergency meeting. Plaintiffs were never invited because in the said meeting notice, the name of the plaintiff does not find place. If at all there was to be emergency meeting to elect or select the new secretary and treasurer for the remaining period, then prior to that there should be a procedure action as contemplated in bylaw number 26. My lords, bylaw number 26, Prakara Bishop has to take action. That was what the trial court said. Kindly see down below, but no documents are forthcoming before the court that the bishop who enjoys the paramount power regulated by principles of natural justice has passed any notice to the plaintiff and the complaint request of the chairperson of the committee. And moreover, no document has been produced before the court to show that who suspended the plaintiff from membership and apart from their post. If the bishop is passed the order, then it should be under bylaw number 26, and if the committee is passed, then it should be no power at all. Executive committee had taken a decision. The court said bishop has to take it. Okay, this is the next document, page 158. Bishop takes the decision. Independent decision on 17/6/2022. This was challenged, keeping them on the suspension. This was challenged by them at page 161, IA number 5. Kindly see, they have challenged this in IA. Your lordship may kindly see page 162. For the reasons shown in accompanying affidavit, it is most respectfully prayed that this honorable court be pleased to stay the operation of the letter dated 17/6/2022, issued by defendant number 1 and communicated by defendant number 2 by email in contravention of the order dated so and so, 21/4/2022. The 21/4 order only, executive committee has no power, bishop has to take decision and tell. I bishop took independent decision. Now this was challenged, and against this the trial court passed its order. Your lordship may kindly turn to page 174. On 16th July 2022. Similarly, your lordship may kindly directly take para 1, page 190, para 12. Page 190, para 12. According to the defendants.
Yes.
Page para 12. According to the defendant, though this court by its order dated 21/4/2000 clearly barred the defendant number 22 in with the plaintiff until before also, even restrained them from causing an interference with plaintiff from discharging the duties of the plaintiff. But that doesn't bar the competent authority from taking the decision in accordance with the bylaw of the KCB, as this court itself in its order observed that it is not in dispute that if the bishop has the authority to suspend members of the Tax Committee and not the executive committee. After holding this, kindly see para 16 at page 196, my lords. whether the order of this court, sorry, page 196, para 16.
Yes.
Para 16. Whether the order of this court is right or wrong or void and whatever, if at all the defendants are aggrieved from the order of this court, they were having an opportunity to present appeal before the honorable court. Under order 43, one of this appeal, they could have regarded under order 39 before by seeking modification of an order to exercise the power and the vested under 326. My lords, the trial court holds that if the trial court says that, for example, superintending engineer is not authority and the chief engineer, I should go before the trial court and take permission if the chief engineer has to take action. That is not the law.
Validity of that order is not before me.
No, that is there.
That order was set aside by this court, confirmed by Supreme Court.
Yes,
So if you were to argue that the order of the trial court is correct or incorrect now,
because the trial court ಅದನ್ನ ಇಟ್ಕೊಂಡೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ A10 ಮೇಲೆ. Trial court has said, kindly see the now present order of the trial court.
I will for a minute not even look into the order. I just want you to satisfy me on I number 10 as to how the prayer in the suit has become infructuous. The trial court may have been influenced by the orders that had passed earlier. I am not influenced by it. I'm only looking at the prayer in the plaint and I'm asking you how the prayers become infructuous for me to entertain this revision on I number 10.
Earlier that challenged the suspension by the executive committee. Subsequently, Bishop has taken an independent decision. That
Fine,
is
if
not
they,
under
if they have not challenged it, they suffer the consequences. How will this prayer in the suit become infructuous? Prayer in the suit will never become infructuous. So I'll simply say that
ಅಲ್ಲ, but ನನಗೆ judgment ಹಾಕ್ಬಿಟ್ಟಿದ್ರು.
whatever you want to do, you do. I'm not, because in the light of this order that I see, I don't think you require any discretion to exercise at my hand.
Discretion, yeah, I will request my lord. Kindly see the discretion. The order was passed on 18/1/2024.
That is not before me. I'm traveling beyond the scope of CR.
Obviously, judgment the 5 days ಹಾಕ್ಬಿಟ್ರೆ how can we challenge that order?
You are smart enough, you know what is to be done, you will do.
5 ದಿವಸಕ್ಕೆ ಇಲ್ಲಿ ಹಾಕ್ಬಿಟ್ರೆ
ಬನ್ನಿ.
ಅಲ್ಲ, observations of the trial court.
This revision is directed
Of the trial court, my lords, I
challenging
hate, with great respect
Order
to the
passed
trial court.
by number 10.
Observations are unnecessary, uncalled for.
by the petitioner was the fourth defendant in the suit. The petitioner, which is the executive committee of the KCD of the Church of South India, filed an application under section 151 of the CPC, seeking for an order to dismiss the suit of the respondent 1 and 2, na?
That's only
Respondent number one
sentence
and-
in the order of the trial court.
Respondent 2 and 3,
Your lordship permission.
1 and 2.
ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಓದ್ತೀನಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪೇಜ್ 33 ತಾವು ಹೇಳ್ತೀನಿ ನೋಡಿ CRP. I will not detain my lords, I'm sorry. Only one paragraph I will read. Page 33 of the order of the trial court. Internal page 20 of the order of the trial court, 10 lines from below my lord. Thus on the start of it.
Yes.
Thus against the act of defendant number 1, no separate prayer is required to be sought, what your lordship said. Kindly see the next sentence. In that event, the question of suit becoming infructuous, consequently seeking relief or dismissal does not arise. That was what court has said. Kindly see the next bit. It is contrary to the earlier this one. That apart, if at all such an additional relief is required to be sought, plaintiff or still can state at any point of time as the alleged cause of action arose during the pendency of the suit. ಇದು ನನಗೆ setback copy ಕೊಟ್ಟಿದ್ದು later on. Later on.
You don't need the advice of the court. You know what is to be done.
ಅಲ್ಲ, ಇವಾಗ
ಇದು-
ಕಾನೂನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ, ನಾನು
ಇದು-
ಆರಕ್ಕೆ ಬರ್ಬೇಕು.
ಇದು ಅವ್ರ ಜವಾಬ್ದಾರಿ ಆಗಿರ್ಲಿಲ್ಲ ಕೋರ್ಟ್ದು. ಏನೋ ನಿಮ್ಗೇನೋ ಕೊಟ್ರು.
ಇಲ್ಲಿ observations ಮಾಡ್ಬಿಟ್ಟು ಆರ್ಸ್ 25,000 ಇಂಪೋಸ್ ಮಾಡಿದ್ದಾರೆ. That my lords, 25,000 at least some relief may be granted. 25,000 cost impose ಮಾಡಿದ್ದಾರೆ.
Filed by
I have
respondent number
exercised my right under CPC.
The suit by respondent 1 and 2 was filed seeking for the following reliefs, page 48. As could be seen from the prayer in the suit, it was one seeking for a declaration that respondents 1 and 2 were the duly elected members of the pastorate committee and were elected to the post of secretary and treasurer of the pastorate committee for the triennium 2021-2024. In my view, such a prayer seeking for declaration that respondents 1 and 2 were duly elected would not be rendered infructuous, since The question as to whether they were duly elected or not was the subject matter of consideration of the suit. Though the trial court has given various other reasons, and though several arguments were advanced before me as to how the impugned order was incorrect, the fact remains that the prayer made in the suit would not be rendered infructuous, and therefore the application filed by the fourth defendant was clearly not maintainable. I therefore find no reasons to interfere with the order passed by the trial court, and the revision is therefore dismissed.
25,000 cost, that page 34. Cut your lordship may kindly.
That can't be by way of a revision. He has to challenge that by way of a writ.
No, the trial court has also taken 7 months to pass an order. Don't
My,
think-
my lord, that may be, but my lord will have no jurisdiction on the revision. It has to be by way of a writ, that portion of the order.
Having regard to the fact that the application was filed seeking for dismissal of the suit for having become infructuous, the trial court was not justified in imposing cost of rupees 25,000. Only to the extent of the cost being imposed to the tune of rupees 25,000, the order is modified, and the order of dismissal is however confirmed.
My lord may consider reduction in the cost. My lord is waived off completely.
I gave you a hint, it's still.
I'm grateful. I don't know whether my lord, as a point of law, does the civil court and the revisional court have jurisdiction to interfere? That's part of the order.
Seal number 24, Shri Rohan Osman.
Funded number 1, my lord.
For the petitioner, pay for a week's time.
Week's time.
Seal number 25, Shri Adi Prasad MB.
Petition, press for 1 week and.
Week's time.
Seal number 26. Satish K.
This is for reporting compliance mode. Order.
Aita.
Comply ಆಗಿದೆ. ಅದು there were some interim orders passed in the writ appeal, which had to be modified. Now it is modified and told.
Complete at the recruitment process, complete.
Compliance ಆಗಿದೆ. I have produced the notification of this. My lord had directed, my lord, that we should give them another option for HK candidates. We gave that option, my lord. And page 3, I have narrated how many people opted. 86 candidates.
Benefit ಆಯ್ತಾ?
Huh?
Benefit ಆಯ್ತಾ?
ಆಗಿದೆ. 86 ಜನ they have taken that benefit.
22 people increase.
And 22 people, not candidates. Additional candidates have got the posts that I have mentioned.
22 ಜನಕ್ಕೆ ಸಿಕ್ತಾ? 22 people.
And next page I have mentioned, my lord, there are 2 sets of writ appeal which are pending. There was an interim order operating 7-2. The division bench has directed us to complete the process by mentioning
But content is.
specifically that there is a pendency of writ appeal and appointments are subject to the writ appeal pending.
On 22nd of August 2023, the writ petitions were disposed of. And at the same time, certain directions were issued. So, the matter was directed to be posted for reporting complaints. Today, a complaints report is filed. This is the one. Stating that pursuant to the direction issued by this court, the selection process was completed not only in accordance with the order passed by this court, but also in compliance of the interim orders granted by the division bench. In view of the complaints report, no further orders are necessary. These writ petitions.
Ready. Bill number 27, Shri Ravi Shankar K.
6th time. There are altogether 17 office objections. The order sheet indicates that the petition was granted 6 opportunities from 4/8/2023 to comply with the office objection. However, the same has not been completed. It is therefore obvious that the petitioner is not interested in pursuing the petition. Petitioner is dismissed on pursuit.
Seal number 28, Shri Nandish Patil. That is, Lordship may grant me 1 week time, Lord.
2000. I should increase it now.
I'll pay the cost. Lordship may grant me. In the meantime, Lord, if your Lordship's permit, I'll have a copy of the standing from
Yeah.
BDM.
Why were you imposed with costs?
Lord, some office objections. Pay it, Lord.
The first court fee ಕೊಟ್ಟಾದ್ಮೇಲೆ notice order ಮಾಡೋದು.
Court fee ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಬಂದಿದೆ.
Lordship may have it next week.
Weeks time.
Bill number 29, Shri Ramatullah Kotwal.
For the petitioner, Lordship. Kindly. Weeks time finally.
Seal number 30, Shri Ashok Ji Patil.
In this case, there's your question. This is some kind of prayers to the petitioner alone. Either facts are. It's a accusation of the KID.
What is the prayer?
Prayer not to what the award and the award of this. Because what happened was, second 29 to notification, notice of issue to her. What is fine. And 29 to notice. Connected AA.
No. AM is the general award.
Yes, but before that, now we got the citation. Notice at the section 29 of the KID. Page 229, connected.
No, if you are challenging the award,
What and the award.
so the award in only insofar as your lands are concerned will be the subject matter.
Only my land. And because 1900 square meters of land is given at 130 was earlier notified a part of it. Now not 1900 square meters are notified. And not section 29(2) notice is issued to us saying that I am entitled to 27 crores 74 lakhs compensation. This amount is limited by DMRC to KID. Without the award being approved by the state round, award notice is issued. And that will not have challenge.
Does this award include your land and other lands also?
The others are claiming under a sale deed after the final notification.
Whatever it is, there are other claimants also.
There are other things.
And the extent of land is a larger extent than the one that you own.
Mine the only land 1900, that they are claiming their right. By a sale deed which has come into existence after the 28th.
But don't you think they should be a party to this?
But I'm safeguarding the interest because the land acquisition officer has committed a blunder here.
No, but you implicate them as parties, then the problem will be solved. Over are the rival claimants. They'll be affected by this order one way or the other.
But they will be benefited. If at all they.
So then they will not oppose you. If you implicate them, they will not oppose you then.
But the only difficulty is, these people are claiming a void to sale deed. And not, their claim, if at all they fail court to consider. But so far as the procedure adopted by the land acquisition officer. But where 29(2) notice ಕೊಟ್ಟಿದ್ದಾರೆ ನಮಗೆ ಕೊಟ್ಬಿಟ್ಟು ಅಲ್ಲಿ award approval ಗಿಂತ ಮುಂಚೆನೆ award notice ಕೊಟ್ಟು. Now they say that you are claiming your.
What is your name?
Ravindra.
There are 2 people here. M.A. Ravindra.
Right, near
A.K.
son of point. Because all others have set up the same deeds subsequent to the date of the, from Karnataka.
No, who are these people? GK Garage.
All the others are claiming under the different bits of land and the different sale deed by all dated subsequent to what, so the 28(4) notification. My purchase is in 2004. Their purchase is 31/5/2020. But my only submission is this. That all not this petition is granted, everybody is granted, and award notice ಕೊಟ್ಬಿಟ್ಟು ಅದು ಅಪ್ರೂವೇ ಆಗಿಲ್ಲ ಇನ್ನು ಗವರ್ಮೆಂಟ್. The record shows that. Only 3 documents not valid when we come to procedural.
What is WP 21204/2022?
But they, I had, after the final notification was issued and published, that the BMRCL and KIDP wanted to amend that, then I said, you have no power, it's for the government to do it. Then the Dishonorable Court gave a direction.
This objection deferred for the present.
Actually, there was three documents, annexed AEA 269.
AGA to take notice for R1 and R2. Who appears for BMRCL?
BMRCL, Harish.
Harish appears to take notice for R3 and R4. KDB here. Sri Chanagouda to take notice for R5 and R6. Relist on.
But my only request is let them not, government should not approve it, not because it's pending before that.
If the entire thing goes, it goes, isn't it? Whether they approve or they don't approve. And the ultimate order is to deposit the money into the civil court only. So your money.
7 crores part of it.
Let us see. Relist.
Maybe it's not 7 March. Naked. Meantime, I'm sorry.
31, Shri Giri Kumar SV.
The two office of business, have first office of business is being declared. And the second office of business, to be speaks the horizontal maintained.
Challenging the award.
Yes, sir.
On what ground?
There was no notice distribution at all. Completely, it is an award without sensitivity, our objection and no notice was. And we even do not know what will happen during the course of the accident. And we have got the rich vegetation is completely.
AGA to take notice for R1. Shilpa Shah to take notice for R2. AGA to take notice for R1 and R3. Shilpa Shah to take notice for R2. Relist on.
11. Number 32, the Ron B. Tigidi.
Respondent. Matter, please, not substantially, please, not disposed of by the Honorable Apex Court on 2 occasions. The division bench has dismissed this petition earlier instance, with fast.
And what is the order?
Let the
For R2 and R3, is that to state whether the portion of the property subject matter writ petition has been taken or not by the KADB? And if taken, the date on which is so taken and produce necessary documents.
The issue, my lord, is now, insofar as the main matter is concerned, it's pending in the Supreme Court. Insofar as the question of whether the acquisition is lapsed or not. And there, my lord, an order was passed on the 7th of January, asking the KIDB as to whether they require the land or not. There is a question there, therefore they have to answer it there. In the meanwhile, my lord, what they do is, they create one document showing handover of land from KIDB to BWSSB. That is what is challenged before my lord, because possession according to us is still with us.
What is the matter with the Supreme Court?
There, my lord, we said acquisition is lapsed. Because of Anusuya Bai, my lord, this court said that acquisition proceedings under KIDB Act can't lapse and therefore dismissed our petitions. That is challenge, and that challenge is pending before the Supreme Court. On the question as to whether it will lapse or not, that is issue is still to be considered. Therefore, I'm not going into that question. Now, when the Supreme Court asks those questions, a handover is made.
Make an application.
No, my lord, not that. Now, the question is of only.
Purchaser, please.
So, one second, please. No, I've not made an application there. I made an application to produce these documents before the Supreme Court.
No.
No, the question, my lord, is not that. Question is whether they've taken possession from me.
That question can also be agitated there.
Lord, not in an SLP, my lord. How can it in an SLP be raised?
Have a sub-story. The main matter is there.
No, main matter is on the question of lapsing. There, my lord, the question is, of course, that today we are only challenging the so-called handover because they're creating a record on this. A handover from KIDB to BWS. Please see the order.
But that is all subject to the.
No, my lord, it is not. Because now they claim, let me say this now. Now they claim, but
if your SLP is allowed, all this becomes
Lord,
superfluous.
no, it may, my lord. But now what they are doing is they are trying to make it appear as if the land has been taken possession of and handed over. I'll give you lots of a few facts, my lord. Because in 2008 till 22, when this order, or 2019, when the order was passed to the Learned Single Division Bench, the finding was there was an order status quo all the time. So now they say, no, 3 months before that we took possession. No court was ever informed of that fact. And your lordships may see the documents that they've placed before your lordships.
I'm not inclined to examine this here in this writ petition when the main petition is pending with the Supreme
But that is not the main petition.
No, in the Supreme Court, the main matter as to whether the lands are acquired validly or whether it's lapsed remains Whatever relief you want, you will have to get it there. You have failed in one attempt to.
Two attempts. Now.
Three attempts, my lord, before the apex court, there
No,
is
no,
failure.
I'm not denying it. Everything has been placed before your lordship, not as if something has been hidden.
Go take a chance there, wait.
No, no, not chance. Now, please see the document. How is it possible, my lord, that when proceedings are pending now,
Once the acquisition proceedings are held to be valid, anything that I do now, especially when matter is pending there, would be incorrect.
no, it won't be, my lord. May I respectfully say this? The reason why it would not be is because under the KIDB Act, the final notification is issued and then possession is sought to be taken. It is not the other way around, like in the case of Land Acquisition Act. In the Land Acquisition Act, until 16 is over, property does not vest with the government. Here, my lord, under 28(4), once the order is passed, it's supposed to vest in the government, and then action should be taken to take possession. Till today, award is not made with respect to these properties. Nothing has been done. The finding of the division bench or the learned single judge in this case last time was, in the last occasion was, that till 2019, there was an interim order and therefore they couldn't do anything with respect to this property. That is the order passed. Now they say in 2008 only we've taken possession. And please see the Mahazar they've produced before, my lord. The Mahazar, my lord, will show your lordship something completely different. I don't even think your lordships can call it a Mahazar. It seems to be something completely created and now produced before the court.
I'll give you liberty to go make the submission there. Why do you want to take a chance here?
No, no, the chance is only on the question. No, I'm not challenging, my lord. Your lordship may kindly appreciate. I'm not challenging the issue as to whether.
You're challenging a consequential action pursuant to the acquisition.
Correct.
The acquisition is the subject matter of the
That is
SLP Supreme Court. So if I were to pass any interim order incidentally relating to taking possession pursuant to the acquisition being upheld, it would be incorrect.
Oh, no, no. This is not with respect to taking possession. This is with respect to handover, so-called handover from KIDB to BWSSB.
This is subject to, this is an event which has occurred after the acquisition which has been upheld.
Please.
So long as your challenge to the acquisition has failed,
Yes.
there's nothing that can be done here. You can at best go there and seek for an interim order, whatever you want against this endorsement. Because all that I can say is once your writ petition has failed here, I cannot permit you to challenge a subsequent handing over possession from KDB to Water Board.
No, the question as to whether possession has been taken has not been answered by any court.
That is not a question which will be available for you to raise because you've lost before this court.
No, lost on the ground that Anusuya Bai doesn't reply. Makes it non-applicable.
I can't redo whatever is done now.
No, it's there in the order itself.
Correct, but there is an order which has nullified your challenge to the acquisition.
No,
So you're challenging something subsequent to the acquisition.
No, may
Until your challenge to acquisition is successful.
No, am I not entitled? I ask myself, am I not entitled to say that possession is still with me?
There.
No,
There.
not there. No, forget, my lord, whether I succeed or not. Am I not entitled to raise a legal issue?
You will lose all rights over the land the moment your challenge acquisition goes. What they do is their consequence.
My lord,
Suppose Water Board has not taken position in accordance with law, it will suffer the consequences. You are definitely out of the picture.
no, my lord.
If the acquisition is upheld, as to what they do with your acquired land, it's no
Lord,
consequence.
even if acquisition is upheld, there has to be a notice under 28(6) before they take possession of the land. Now, that is not done in this case. There is no notice issued to anybody, my lord, insofar as taking possession is concerned. Now, they issue a notice under 9 and 10 of the Land Acquisition Act 1894 to fix the compensation. That also is not served on me. I get a copy when I go there. Therefore, question, Lord, as to whether and what steps must be taken in relation to actual takeover of possession is a completely different issue. Because even if, my lord, let me say, even if acquisition is upheld, that 28(4) notification is upheld, and my argument on lapsing fails because to the KIDB Act, the provisions of 24 does not apply because of Anusuya Bai's case. Still, whether you've taken possession properly from me is a question which requires to be answered. That, Lord, in my humble submission, would be completely different from that issue. If you've not taken possession in a manner known to law,
Otherwise, you're running a risk. Suppose they produce something and I say they've taken possession, then
it'll affect it.
so that's why I'm suggesting.
Lord,
that-
I'm so confident after seeing the document that they produced that no one can ever say that. That's the only reason I'm before your lordships.
Objections hakidira?
Illa, just now, my lords, the
Just
only
now,
please
last time.
been filed.
The specific order that is passed.
Please, my lords, we will file it, please, my lords. I just entered appearance, my lords, a day ago. My lords, I will file it, please, my lords, in 2 weeks. My respectful submission, please, my lords, all these aspects have been considered.
No, no.
My lords, the only, my lords, ray of light available, please, my lords, is only with regard to, my lords, seeking of compensation. He can only claim compensation, my lords. He cannot even seek for enhanced compensation. That is the position, please, my lords, with
There is
regard
some
to a
notice
subsequent
regarding
purchase.
I want your lordship to see. I'll show all those documents then.
38(6) notice.
Please see there's notices. It's not issued to anyone specifically. It is supposed to have been issued.
Purchase,
One minute.
please, my lord. That
No, no,
aspect
but
is
you are
addressed
issuing.
in the petition.
They don't make a mention, please, my lord, the fact that he's a subsequent purchaser.
That is there in the orders itself.
That is
But
the
I'm in
fact.
possession of the
But he has to
property.
plead, please, my lord, with fairness, he has to plead before the court, please, my lord, that he's a subsequent purchaser. He suppressed that fact itself.
Please see para 4.
Reference of date.
Every date is there.
Lord, date, my lords, with regard to his acquisition of the property and the sale deeds. My,
It said
the
so
acquisition is
specifically,
prior to this.
6 to
So, my lord,
2006.
he has to state, please, my lords, in very many terms, please, my lord, that is a subsequent purchaser.
File your objections.
Please, my lord.
As directed by the court on 16 to 2024. The counsel for respond number 2 and 3 files a memo along with 5 documents. The same is taken on record.
So the entire money we have deposited, please, my lord, to the year 2008, please, my lord. 14 crores we have deposited then.
But I honestly think it's better that you go to,
I'll consider that as well.
because any observation that I made this way or that way will affect either, if not you, at least them, so.
And
Yes.
our project, please, my lord, the huge project, my lord, the Bangalore.
There's
please,
no
my lord,
project they've done.
but
For the last
only
20 years, they've not done a
aspect, we have
project.
already issued the tenders. L&T is going to construct it. 36 acres, my lord, is a requirement, please, my lords, of the day. Grateful.
Hearing I.
Or should we fix a date, no? To
When can you file objections?
Within about 3 weeks, my lords, may I request, my lords?
The list of 2 weeks, 700.
3 weeks, my lords, request.
You're pleading such a big urgency and you're not
But
prepared.
I
to
will file it, please, my lords. I have to get the
File
approval.
it within 2 weeks. If
Please.
you're urgent, it's urgent.
I will do that.
11.
Great.
11. Seal number 33, should we be revision?
For the respondent number 2, my. Dismissed for non-prosecution, my lord.
To recall the audit cards. I was head up in the NCLT there, the lords on that day.
Recovery of money. What is the order that is passed?
Non-prosecution dismissal.
Impugn order.
Impugned order.
So dismissed,
Small
your
cause
lords.
court.
Again,
Recovery suit
dismissal
dismissed.
Order, I'm there before your lord.
Recovery suit dismissed.
Yes.
Suit for recovery.
The reason stated in IA 1/23. The order date 3/3/2023 is recalled.
My lord, date may be fixed, my lord. There is oldest matter.
ಯಾವತ್ ಮಾಡ್ತೀರಿ?
Any date.
Any day. 2 weeks, 2 weeks.
ಅವತ್ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸೈಡ್
ನಾನು ಆಯ್ತು.
ರಿಲಿಸ್ಟ್ 2 weeks ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ. 2014 10-year-old revision.
Next 2 weeks ಕೊಡ್ಬಿಡಿ ಮಾಡಿ.
2 weeks ಬೇಡಿ. ರಿಲಿಸ್ಟ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
Oblige, my lord.
Number 34. M. Ramaya, party in person.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ವಾ ನೀವು?
ಎಲ್ಲ ಅಪ್ಲೈ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಕೋರ್ಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು.
ಬ್ಯಾಲೆನ್ಸ್ ಯಾವ್ದು ಇಲ್ಲ. 7 ವರ್ಷ ಆಯ್ತು ಸ್ವಾಮಿ. 14,000 ರೂಪಾಯಿಗೆ WP ಹೋದೆ, ಅವರು ಅಲ್ಲಾಗಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಕಳ್ಸ್ಕೊಡು. 14,000 ರೂಪಾಯಿನ ಕಳ್ಸ್ಕೊಂಡ್ರು. ಇತ್ತಿಗೆ ಕಾರು ಕೊಟ್ಟಿಲ್ಲ. ಇನ್ವಾಯ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ಮಾಡಿ.
ಎಲ್ಲಾನು ಕೋರ್ಟಿಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿದೀನಿ ಸುಮ್ಮನೆ.
ಏಳು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
7 ವರ್ಷ ಆಯ್ತು.
7 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು ಇಲ್ಲ. ಎಲ್ಲ ಓದ್ತೀನಿ. ಎಲ್ಲ ಕ್ಲೀನ್ ಆಗಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ತೋರಿಸಿ. ಇದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ರೀಕಾಲ್ ಮಾಡ್ತೀನಿ.
ಈಕ್ವಲ್ ಆಗಿ ಎಲ್ಲ ಕ್ಲೀನ್ ಆಗಿ
ನೋಡಿ ಅಷ್ಟು 7 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದೆಲ್ಲ ಕಂಪ್ಲೀಟ್ ಕ್ಲಿಯರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಮ್ಮ ಆಫೀಸ್ ಪ್ರಕಾರ ಅದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ನೋಡಿ ಮಾಡಿ ಕಂಪ್ಲೀಟ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಇಲ್ಲೂ ಬಂದಿದೆ. ಯಾವುದು ಬ್ಯಾಲೆನ್ಸ್ ಇಲ್ಲ ಸರ್. ಅಬ್ಜೆಕ್ಷನ್ ಯಾವ್ದು ಬ್ಯಾಲೆನ್ಸ್ ಇಲ್ಲ. 7 ವರ್ಷ ಆಯ್ತು. WP ಆಗ್ತಾ WP ಓಕೆ ಆಯ್ತು. ಅವ್ರೇನ್ ಮಾಡೋದು, ಇಲ್ಲಿ ಬರ್ಬೇಕು CRP ಹೋಗೋದು.
Since the office objections have been complied with, the order dated 2/8/2022. Dismissing the CRP for non-prosecution, record and television restored. ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ ನೀವ ನಿಮ್ ಮಗನ? ಅಡ್ವಾನ್ಸ್ ಕೊಟ್ಟಿದ್ ನೀವ ನಿಮ್ ಮಗನ?
ಯಾವ್ದು ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು
ನಿಮ್ಮ ಬುಕಿಂಗ್ ಯಾರ ಹೆಸರಲ್ಲಿ ಮಾಡಿದ್ದು ಕಾರ್?
ನಮ್ಮ ರಾಮಯ್ಯ ನಾನು ಸ್ವಾಮಿ.
ಇಲ್ಲ, ಕಾರ್ ಯಾರ ಹೆಸರಲ್ಲಿ ಬುಕಿಂಗ್ ಮಾಡಿದ್ದು? ನಿಮ್ಮ ಹೆಸರಲ್ಲ ನಿಮ್ಮ ಮಗನ ಹೆಸರಲ್ಲ?
ನನ್ನ ಹೆಸರಲ್ಲೇ ಸ್ವಾಮಿ, ನನ್ನ ಹೆಸರಲ್ಲೇ ಮಾಡಿದ್ದು.
ರಸೀದಿ ತೋರಿಸಿ ನಿಮ್ಮ ಹತ್ರ ಇರೋದು.
ಅದು ಎಲ್ಲ ಅಲ್ಲಿ ಲೋಯರ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಲೋಯರ್ ಕೋರ್ಟ್ ಫುಲ್ ಕೊಟ್ಟಿದೆ ಎಲ್ಲ.
ಲೋವರ್ ಕೋರ್ಟ್ ಬರ್ದಿರೋದು ನಿಮ್ ಮಗನ ಹೆಸರಲ್ಲಿ ಬುಕಿಂಗ್ ಮಾಡಿದ್ದು.
ಇಲ್ಲ ಇಲ್ಲ, ನನ್ನ ಹೆಸರಲ್ಲೇ ಸ್ವಾಮಿ.
ಈ ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ಮ ಹೆಸರು, ನಮ್ಮ ಮಗನ ಹೆಸರು.
ಅಲ್ಲ, ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಮಾಡಿಲ್ವಾ ಈಗ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲೇ ಆರ್ಡರ್ ಕಾಪಿ.
ಪೇಜ್ ನಂಬರ್ 10ಕ್ಕೆ ಬನ್ನಿ. ಪೇಜ್ ನಂಬರ್
ಲೋಯರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್ ಇಲ್ಲ.
ಅದೇ ಪೇಜ್ ನಂಬರ್ 10 ತಗೊಳ್ಳಿ. ಇದ್ರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 10. ಪ್ಯಾರಾ 9, 10 ಓದಿ.
ನಲ್ಲೂ ನನ್ನ ಹೆಸರಲ್ಲೇ ಇದಾಗಿರೋದು.
ನನ್ನ ಪ್ರಕಾರ ನಿಮ್ಗೇನ್ ಕೇಸ್ ಇಲ್ಲ. ನಿಮ್ಗೆ
ಸ್ವಾಮಿ,
ನನ್ನ ಪ್ರಕಾರ ನಿಮ್ ಕೇಸ್ ಇಲ್ಲ. ಜಜ್ಮೆಂಟ್ ಸರಿ ಇದೆ. ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ತಪ್ಪಿಲ್ಲ.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರೇ ಸುಮ್ಮನೆ ಇರೋದು. ಜಡ್ಜ್ಮೆಂಟ್ ನನ್ನ ಹೆಸರಲ್ಲೇ ಇರೋದು.
ಕರೆಕ್ಟ್, ಜಜ್ಮೆಂಟ್ ಸರಿ ಇದೆ. ಇದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ನಿಮ್ ಕೇಸ್ ವಜಾ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ನಿಮ್ ಕೇಸು ವಜಾ ಮಾಡ್ತಾರಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು 7 ವರ್ಷದಿಂದ 14,000 ರೂಪಾಯಿಗೆ WP ಬೇರೆ ಹಾಕ್ಬಿಟ್ಟು WP ನಲ್ಲಿ ಎಲ್ಲ ಆಗಿ ನೋಟಿಸ್ ಎಲ್ಲ ಆಗಿ ಅವ್ರು ಬರಲ್ಲಪ್ಪ CRP ಹಾಕು ಅಂತ ಸಾಹೇಬ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಇಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ ಆರ್ಡರ್. 30/7/98/19. ಅದರಿಂದ ನೋಡಿ ಅವಕಾಶ ಮಾಡ್ತೀನಿ ಸರ್. ಅಮೌಂಟ್ ಕಟ್ಟಿರೋದು ನಮ್ಗೆ ವಾಪಸ್ ಕೊಡ್ತೀವಿ. 7 ವರ್ಷ ಆಯ್ತು.
ಏನಿದ್ರೆ ಹೇಳಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬಿಡಿ ನಿಮ್ದು.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ಸುಮ್ಮನೆ. WP ಹಾಕಿದೆ, WP ನಲ್ಲಿ ಎಲ್ಲ ಓಕೆ ಆಯ್ತು, ನೋಟಿಸ್ ಮಾಡೋದು.
ಅಲ್ಲ, ಈ ಜಜ್ಮೆಂಟ್ ಏನ್ ತಪ್ಪಿದೆ ಹೇಳಿ ಸಾಕು. ಅಮೇನವ್ರೆ, ಈ ಜಜ್ಮೆಂಟ್ ಏನ್ ತಪ್ಪಿದೆ ಹೇಳಿ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ನನ್ ಕಡೆ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್. ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ ಒಪ್ಕೊಂಡ್ಮೇಲೆ ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ, ನಮ್ಮ ಮೇಲೆ ಇದ್ ಮಾಡ್ಬಿಟ್ಟು ಪ್ಲಾಂಟಿವ್ ನ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದರಿಂದ ನಮ್ಗೆ ಅಮೌಂಟ್ ಬರಕ್ಕೆ ಅವಕಾಶ ಮಾಡ್ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಇಲ್ಲಿ ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ ಮೇಲ್ಮನೆ. ಈಗ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಬುಕಿಂಗ್ ಮಾಡಿದ್ದು.
ಲಾಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಹೇಳಿ ಎಲ್ಲ ರೆಡಿ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಎಲ್ಲ ರೆಡಿ ಕಾರ್ ತಗೊಳ್ಳಿ ರಮೆ ಅಂದ್ರೆ, ಇಲ್ಲ ಸರ್ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರು ಯಾರು, ನಾವೆಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಟಕ್ಕಾಗತ್ತೆ ನಮ್ಗೆ ಇದಿಲ್ಲ ಅಂದ. ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲೆ ಇನ್ನೊಬ್ಬರು ಜಡ್ಜ್ ಬಂದು ಏನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ಟು ತಿದ್ದುಪಡಿ ಆಗಿದೆ ಅದಾಗಿದೆ ಅಂತ ಸುಳ್ಳು ಹೇಳ್ಬಿಟ್ಟದೆ ಇದು ಮಾಡಿದಾರೆ. ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಪ್ಲೇಂಟಿಫ್ಗೆ ದುಡ್ಡು ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ರು, ಕಟ್ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರು. ಅಯ್ಯಪ್ಪ, ಆಮೇಲೆ ನೋಡಿದ್ರೆ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ರು. ಅದಕ್ಕೆ ನಾನು 7 ವರ್ಷದಿಂದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೊಡೆದಾಡಿ ಕಟ್ಟಿರೋ ದುಡ್ಡು ತಗೊಳ್ಳೋಣ ಅನ್ಬಿಟ್ಟು ಇದು ಮಾಡಿದೀನಿ ಸರ್.
ಕೋರ್ಟ್ ಹೇಳಿದೆ ನೀವು ಕೊಟ್ಟಿರೋದೇ 4,000 ರೂಪಾಯಿ ಅಂತ. 4,000 ರೂಪಾಯಿ ನೀವೆಲ್ಲ ಕೊಟ್ಟಿರೋದು ನಿಮ್ ಮಗ ಕೊಟ್ಟಿರೋದು. ನಿಮ್ ಮಗ HDFC ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಮ್ಯಾನೇಜರು. ಅವ್ನ್ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ಲ, ನನ್ ಕಾಸು ವಾಪಸ್ ಕೊಡಿ ಅಂತಂದ್ರೆ ನೀವ್ ಅವನ್ ಪರ ಕೇಸ್ ಹಾಕಕ್ ಆಗಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಕೇಸ್ ಹಾಕ್ಬೇಕು.
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇಲ್ಲಿ ಕಾರ್ ಬೇರೆ, ಅವ್ರ ಹೆಸರಲ್ಲೇ ಬೇರೆ ಇದೆ. ಅದು ನನ್ನ ಹೆಸರಲ್ಲಿ ಇನ್ನೂ ಇದು ಬಂದಿದ್ದು, ಇನ್ವಾಯ್ಸ್ ಬಂದಿದ್ದು. ಅದನ್ನ ಅವರು ಸೀಲು ಗೀಲು ಎಲ್ಲ ಹೊಡೆದಿದೆ. ಇದು ಗಿರೀಶ್ ನಾನು ಇಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ. ನನ್ನ ಹೆಸರಲ್ಲಿ ಇದು ಸೇಮ್ ಇನ್ವಾಯ್ಸ್ ಇದೆ ಎಲ್ಲ. ರೆಂಟೆಡ್ ರೆಕಾರ್ಡ್
ಇನ್ವಾಯ್ಸ್ ನಿಮ್ಮ ಹೆಸರು ಇರ್ಬೋದು, ಬುಕಿಂಗ್ ಅಮೌಂಟ್ ಅವನ ಹೆಸರು ಇದೆ. ಬುಕ್ಕಿಂಗ್ ಅವನ ಹೆಸರಲ್ಲಾಗಿದೆ.
ಸುಮ್ಮನೆ
ಬುಕ್ಕಿಂಗ್ ಅವನ ಹೆಸರಲ್ಲಾಗಿರೋದು.
ಅದೇ ತಪ್ಪು ಮಾಡಿದ್ದಾನೆ, ತಪ್ಪು ಹೇಳಿ ಮಾಡಿದ್ದಾನೆ ಸ್ವಾಮಿ. ಅದ್ರ ಸೀಲು ಎಲ್ಲ ಇದೆ ಅದ್ರಲ್ಲಿ, ಎಲ್ಲ ನನ್ನ ಕಡೆನೆ ಮಾಡಿದ್ರು. ಸೀಲು ಎಲ್ಲ ನೋಡಿದ್ರೆ ಏನ್ರಿ ಸೀಲು ಎಲ್ಲ ಹೊಡೆದ್ಬಿಟ್ಟು ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ರಲ್ರಿ. ರಾಮಾಯಣ ಹೆಸರು ಇನ್ವಾಯ್ಸ್ ಇದೆ, ಇದು 2ನೇ ಸಾರಿ ಇನ್ವಾಯ್ಸ್ ಅವ್ರಿಗೆ ಇದು ಮಾಡಿದ್ದು ಇದಲ್ಲ. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಇದಕ್ಕೆ ತೋರ್ಸಕ್ಕೆ ತಗೊಂಬಂದು ಇದೇ ತರ ಎಲ್ಲ ಫುಲ್ಲು ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಇದಕ್ಕೆ ಲೋಯರ್ ಕೋರ್ಟ್ಗೆ ಒಂದು ಮಿಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇವರು ದುಡ್ಡು ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಅನ್ಬಿಟ್ಟು ಸರಿ ಅನ್ಬಿಟ್ಟು ಇದು ಮಾಡ್ಬಿಟ್ಟು ಪ್ಲಾಂಟಿವ್ ಡಿಸ್ಪ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಕಾಸ್ಟ್ ಅಂತ ಇದು ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಕೆಳಗೆ ಕೋರ್ಟಲ್ಲಿ ಯಾರಿದ್ದಿದ್ ಲಾಯರ್ ಅವ್ರಿಗೆ?
ಸುಮ್ಮನೆ
ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಅವ್ರ ಲಾಯರ್ ಹೆಸರೇನು?
ಲಾಯರ್
ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ
ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಲಾಯರ್ ಹೆಸರು
ಇಶ್ಯೂ ನೋಟಿಸ್
ಎಚ್ ಎ ಅಂತ ಇದೆ.
notice to
ಅಡ್ವೊಕೇಟ್
respondent.
ಎಚ್ ಎ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ರಿಲೀಸ್ಡ್ ಆನ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ.
ಎಚ್ ಎ ಅಡ್ವೊಕೇಟ್ ರಾಮಯ್ಯ 14%.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಡೇಟ್ ಕೊಡ್ತೀನಿ.
12ನೇ ತಾರೀಕು 12/3
ನೋಟಿಸ್
number 35 Sri J. M. Anand.
Survey number 270 of Manchanalli village was acquired in the year 1942 by the government to rehabilitate the villagers of Mlad.
You are seeking for review of the order passed on 14 June 2019.
Yes,
Covered anta ಮಾಡಿದ್ದಾರೆ.
covered anta madi, it is not covered.
Petition is also not a party to the petition.
These petitioners are not parties to the petition. Lord, in the year 2017, Lord, the acquisition is of the year 1942.
Who are you?
Lord, in survey number 270, which was acquired in the year 1942.
Mahadeva had filed a writ petition
Yes,
challenging
the acquisition notification issued in the year 1942 by the then Mysore government. That
the
after acquisition,
notification is quashed.
yes,
You had not challenged the notification.
because after acquisition, the village was formed by the government and sites were allotted to these petitioners. The petitioners is in possession since more than 50 years. So in the year 2017, the first respondent herein filed a civil suit before the court similar against these petitioners.
Mahadeva.
Yes, Mahadeva filed civil suit before the civil court. But for declaration, possession, injunction and mandatory injunction during the pendency of this
What was the lands
suit.
acquired for?
Blood
What was the lands acquired for?
acquired for to rehabilitate the villagers of Manchanalli village.
Where is this order passed in WP?
Blood annexure A.
61402, on the basis of which this order was passed.
61402, I have not made it as annexure, but I have copy.
Because until that order is called.
But this order is with respect to only copy. This is with regard to Mlad. So BMIC infrastructure corridor project.
Issue notice. To BS Nagaraj is directed to take notice. For respondent number 1. AGA to take notice. For respondents 2 to 6.
Yes,
2 to 6. HCG.
Blood I sought for interim for this reason.
Yeah, but ಕೊಡ್ತೀನಿ.
Alla,
This order was passed in 2019.
last occasion also not the government advocate directed. Last occasion
It
itself.
was passed 5 years ago.
5 years, but it was produced for the first time before civil court in the 2021.
If I were to grant an interim order without hearing them,
Blood, reason is this, man. The petitioners are in possession. It is stated so in the original suit itself. So though we are the defendants, the first respondent here in by suppressing that fact, filed a writ petition during the pendency of the suit. Suit was filed on 15/12/2017. By that time, the defendants, the petitioners are appeared before the court and filed a written statement.
parties to maintain status quo as it exists today.
Number 36 Karthik B.
For amendment will be heard along with.
An amendment ಏನು?
Amendment short for is some
Amendment
additional
application.
grounds and prayer.
Allow the application. I want to file. Today I received the form. You want to file objections in amendment application? ಆಗ್ಲಿ ಬಿಡಿ amendment ಕೇಳಬಾರ್ದು ಅವರು.
Additional grounds.
What is the application that you filed?
For some, after paragraph 2 to add paragraph 2A and M. My lord.
ಬರೀ prayer ಮಾತ್ರನಾ?
Prayer matra, additional grounds and also prayer. My lord.
An application is filed seeking to incorporate certain facts ಹೇಳ್ತಿದ್ರೆ ಇಲ್ವೋ?
ಇತ್ತು sir.
Seeking to incorporate paragraph 15A to 15C after paragraph 15 and to add para 2A after prayer 2. The application is allowed subject to the admissibility and legality of the prayer sought for by way of amendment. Additional objections, if any, will be filed within a period of 2 weeks.
Obligement.
Seal number 37, Shri K.M. Somshekara.
Designated senior counsel is in VC, my lord.
ಏನ್ ಡಿಸ್ಪೋಸಲ್ ಏನು?
I appear for the petitioner's counsel.
Yes.
ಅದು ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ, ಬಟ್ ಇದು ಹಿಯರಿಂಗ್ ಯಾವೆಲ್ಲ ಮಾಡಿದ್ರೆ ಹರ್ಡ್ ಅಂತ.
ರೂಲ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಇದು ಸ್ಟೇ ಇದೆ. ರೂಲ್ ಇಶ್ಯೂ. Rule.
So another matter in respect of the very same Justice Anand Bera Reddy has quashed it, but I'll have to give the facts of the case also.
Post in B group.
Seal number 38.
Amendment application as well as rejoined. Both as not.
Vacating stay. Who has filed?
We have filed a application for vacating, my lords. If my learned friend has.
Order granted.
Only interim, madam lord.
Dispose the petitioners of the lands concerned other than the portion which is actually required.
For the purpose of
the
their whole case, my lord, the acquisition is only for the purpose of formation of the road. Our case is acquisition is for the purpose of the industrial area, my lord.
No.
Therefore, my lord, that is because of that, the interim order was passed saying that the road portion should not be disturbed. We'll hear the main matter. Whenever instead of hearing the IM, the main matter itself can be heard. My lord.
And only blood the notification issue to connectivity to the blood the
main matter ready there.
Main matter. An application is to
Amendment.
amendment ಇದೆ.
ಇಲ್ಲಿದೆ.
ಹಾಕಿದೆ ನೆನ್ನೆ ಶುಕ್ರವಾರ ಹಾಕಿದೆ. If that application will be allowed along with blood.
Or constitutional validity challenge ಮಾಡಿದ್ದಾರೆ. That can be.
Allow the applications.
Well, that is covered by the division bench judgment itself. Constitutional validity of the KDB Act has already been upheld.
I'll allow the application then on merits.
Subject to objections. I mean, additional objection to be filed.
A prayer is made seeking for.
Blood is similar notification blood.
An additional prayer.
Blood.
Subject to the admissibility and legality of the prayer sought for. The application is allowed.
You know, blood, similar notification has been quashed by the Honorable Court. Final notification has been quashed.
Ready ಇದರ ಇಲ್ಲ?
ಅವತ್ತು ಹೇಳಿ submission ಮಾಡ್ತೀನಿ. Date to last Friday.
Post in B group.
Friday blood.
Any date may be given.
Friday.
Date ಕೊಡಿ.
Monday, my lord. Please.
Friday.
Ready?
Fourth. For admission, seal number 39, Sri Rahul Kariappa.
Yakrele? Fourth and.
Your Lordship, the suit itself is dismissed for non-prosecution.
Is that so?
I seek for time in the next week, my lord.
Say suit is dismissed. So what will you do with the revision?
My lord, suit is for permanent injunction, my lord,
Your revision is against which order?
against the judgment.
On 4/6/22, long back,
Judgment and decree 27.
No suit dismiss again.
OS 5/14, out of which this petition.
So this is against OS 21/2002 tane.
5/14.
5 of 2004.
4.
Which case are you referring to? Seal number 39.
Seal number 39.
39.
CRP 277 of 2014.
The prayer is to set aside the judgment and decree dated 25/4/2013 in OS 21/2012.
No, my lord. It is judgment and decree dated 27/3/2015.
I think you have the wrong file.
Please.
Because the file that I have says you are challenging OS 21/2012.
Sir, over.
Tahira Begum versus Syed Ahmad and two others, Waqf Board and Hazrat Dil
All of
Baksha.
Sharif and others. All of Sharif and others.
ನಿಮ್ಮ ಹತ್ರ ಯಾವ ಪೇಪರ್ ಇದೆ? ಯಾವ ಪೇಪರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ದೀರಾ?
Allah, it is on revision petition 277 of 2015, my lord.
This is 277.
277.
277.
ಕೊಟ್ಟಿದ್ದಾರೆ.
277.
ಲಕ್ಷ್ಮಣ್ 2013 ಕೊಟ್ಟಿದ್ದಾರೆ. 277/2013. First it will constitutional 277/2015. Next week. They have sent the wrong file. They have sent 277/2013.
Because it was a judgment on OS 5 of 2004 itself. Next week.
Seal number 40.
Obliged.
Sri L. Mallesh.
Filed an appeal before the appellate court, and there was a delay of 30 days, my lord, in filing the appeal. And an application was also filed for continuation of delay, my lord. The appellant was represented by our power of attorney holder, and he
ಎಷ್ಟಿದೆ delay?
30 days, my lord. I will leave it to the.
The revision is filed challenging the rejection of an application filed under section 5 of the Limitation Act. As there was a delay of about 30 days,
Please, my lord.
preferring the appeal, an application seeking for condemnation of delay was filed under section 5 of the Limitation Act. The trial court has refused to condone the delay, and hence the petition is before this court by way of this revision. In regard to the fact that the delay in filing the appeal was only 30 days, in my view, the appellate court ought to have condoned the delay and heard the appeal on merits. Consequently, the impugned order set aside. The delay in filing the appeal is condoned, and the appellate court is directed to consider the appeal on merits and dispose of the same at the earliest.
For hearing B group. 41 adjourned. Seal number 42. Siddhappa BM.
Next week.
2015.
Yes, 14.
Lord, in the meantime,
Next week.
I'll file my
Speak ಅಷ್ಟೇ liberty.
Please.
memo on file ಮಾಡಿ
ಏನಕ್ಕೆ?
ರೆಡಿ ಯಾಕಂದ್ರೆ ಅನ್ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿದ್ದಾರೆ ಅದು ಇಟ್ಸ್ ಆಲ್ರೆಡಿ ಡಿಸೈಡೆಡ್ ಇನ್ ದ ಲಾಪಿಟ್ಸ್ ಕೋರ್ಟ್.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಇಲ್ಲಿ?
ಅಕ್ವಿಷನ್ ರೈಟ್ ಆಫ್ ಯೂಸರ್ PMP
PM
ಬರಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಹೇಳಿ ಇವರು ಇಲ್ಲಿ ಕ್ವಶನ್ ಮಾಡಿದ್ರು, ಬಟ್ ಇಟ್ ಇಸ್ ಅನ್ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು
ಅದೇ prayer
But,
ಇದೆಯಲ್ಲ.
ಅದು
Same
prayer ಇದೆ.
prayer.
Same prayer. ಆ prayer it has Supreme Court already it has been, the apex court it has ಆಗಿದೆ ಅದನ್ನ ಮತ್ತೆ. That's why I'm placing it on record.
They're challenging some order pass with district judge.
On district judge
Second
as
prayer.
well as first prayer.
Second prayer ಉಳ್ಕೊಳ್ಳಲ್ಲ ಅಂತಾರೆ.
Second prayer ಬರಲ್ಲ.
First prayer ಏನು? What is Anesh Sharif?
Quashing that
Quashing the
petition
judge.
file ಮಾಡಿ district court.
Claim petition.
ಅದು ಕಾಂಪನ್ಸೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು
Ready ಇಲ್ವಾ?
Ready ಇಲ್ಲ sir, next.
Seal number 43, Shri M.R. Hiramata. State Millard. All the respondents.
ನೋಡಿದಾರಾ?
Next week.
Seal number 45 to 46 adjourned. Seal number 47. Shri Narendra TV Gowda.
Yes, appearing to the respondent minutes. Because we have not filed objection, we are filing it today minutes.
You're filing?
Filing it today minutes.
next week ತೋರಿಸ್ಬೇಕಿಲ್ಲ.
Seal number 48. Submit.
Declaration of lapse insofar as HBR layout third stage is concerned. The pleadings are complete, my lords, in this matter.
My lords, kindly pass over, my lords.
49 adjourned. Seal number 50. Sakar GV.
For a change of land use. Based on a circular, they are not considering the
Opposing. Who's opposing you?
government, my lord. Based on a circular, they have issued endorsement.
For BDH, respondent BDH.
Left, Friday. Friday.
Next week.
51, 52 adjourned. Seal number 53.
ಅಡ್ಜರ್ನ್ ಆಗಿದೆ. ಟೈಮ್ ಕೇಳಿದ್ರು ಅವ್ರ ಬಗ್ಗೆ.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಡೈರೆಕ್ಷನ್ ಕೇಳಿದ್ದೆ ಸ್ವಾಮಿ. ಈಗ BDI is the opponent, my lord, sir.
Somebody
Day
asked
before
for-
yesterday,
Our Basuvaraj HT.
ಅಲ್ಲ interim order I have sought for, I have argued the matter. Allotment was made in the year 2006, my lords. Covered by the decision of this honorable court, interim order was granted, my lords. I have made a submission in similarly situated cases.
51 time total. 51. 51 they have taken time in the morning.
ಅಲ್ಲ ಸುಮ್ಮ ಅದೇ that's what ನಾನು ಹೇಳ್ತೇನೆ. I argued the matter on Friday.
Wednesday.
ಆಯ್ತು.
Seal number 53.
Petitioner, my lord, place time, my lord.
52. Seal number 52. Shri G. Balakrishna Shastri.
G. Balakrishna Shastri.
Time ಕೇಳಲ್ಲ ಬೆಳಗ್ಗೆ. Last chance.
Number 53, T. Srinivas.
Praise time, my lord. Kindly have it on
Last
Friday, my
chance.
lord. Yes, my lord.
Next week. ಎಷ್ಟಿದೆ ಪಾಸ್ವರ್ಡ್?
Passed over matters. Seal number 7.
Time ಕೇಳಿದ್ರು.
Srikanth NB.
ಯಾರು ಕೇಳ್ತೇನೆ? ಏನಕ್ಕೆ ಅಂತ ಕೇಳು. ಏನಕ್ಕೆ ಅಂತ ಕೇಳು.
For the petitioner. Serial number 7, my lords.
ಏನ್ ಮಾಡ್ಬೇಕು?
Other side copy ಕೊಟ್ಟಿದ್ದೇನೆ sir. Will take the instruction.
ಯಾರು ಕೊಟ್ರಿ?
BB Patil.
Release.
In the meantime, my lord, I will complete the observations also, my lords.
Meeting. 2:30.
Please. ಇಲ್ಲೂ ಎಲಿಟ್ ಬಿಟ್ಟಿದ್ದಾರೆ 15 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫೋರ್ ತ್ರೀಗೆ ಒಂದು ನಿಮಿಷ ಅದು ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಆಫೀಸರ್ ಫೋರ್ತ್ ಇದೆ ಸರ್ ನೀವು ಲೇಟ್ ಬೇಕಾ ಸ್ವಲ್ಪ ಲಾಂಗ್ ಡೇಟ್ 11th serial number 16 or 11th ಇದೆ Sixteen, 11th. Thank you. ಒಂದು ಉಲ್ಟಾ ಇಟ್ಬಿಟ್ಟಿದ್ದೀರಾ 13 ವರ್ಷದ್ದು ಬೇರೆ ಕಡೆ ಇಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇದು ಇಲ್ಲಿ ಇದೆ ಇಯರ್ ಡಿಫ್ರೆನ್ಸ್ ಇಯರ್ ಮಾತ್ರ ಡಿಫ್ರೆನ್ಸ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ನೋಡಿ ಸೇಮ್ ನಂಬರ್ ಇಯರ್ ಬೇರೆ ಇದೆ ಫೈನಲ್